Well, good morning, everyone, and welcome to this workshop. Ben and I are going to be speaking about the practical and legal pitfalls in letter of indemnity claims, and in particular, looking at two relatively recent decisions. First, the Tenacity, which I'm going to be speaking about, and then Ben's going to be talking about his case, the Miracle Hope, which came to an end after a long saga that didn't complete until October of last year. So I'm sure many of you are familiar with LOIs, but the general principles are worth looking at. They play a very important role in facilitating international trade, and that's because the fundamental duty of the carrier to deliver the cargo against presentation of the bill of lading. Failure to do that constitutes a breach of contract, but it frequently happens that the bill isn't available at the discharge port. There are many reasons for this. Cargoes are often sold float, sometimes multiple times, and the original bill takes a while to find its way down the chain to the ultimate receiver. In addition, the original bill is often held as security by the funding bank, who might still have it. So when the vessel gets to the discharge port, the receivers want their cargo. The ship owner doesn't want its vessel just hanging around at the discharge port for a prolonged period of time. And the time charterers don't want to pay more hire than they need to. And the LOI is designed to address this situation. It indemnifies the ship owner against the consequences of discharging the cargo without the bill or at a different port. And the charter party will often contain a provision for charterers to demand that the cargo be discharged against an LOI. LOIs are almost always in a standard form. The International Group of P&I Clubs has published standard form wording, and I've included an example of that wording in the handout. So this is a standard form letter of indemnity to be given in return for delivering the cargo without production of the original bill of lading. And the cargo and the bill are identified. And then what the ship owner is requested to do is set out in the recital to deliver the said cargo to X or to such party as you believe to be or to represent X without production of the original bill of lading. And in consideration of the ship owner complying with that request, there's provision in clause 1 for an indemnity against the consequences of following the order. In clause 2, an obligation to put the ship owner in funds to defend any cargo claim. And in clause 3, an obligation to provide security to prevent the arrest or release the vessel from arrest. And it's that obligation to provide security that Ben and I are going to be focusing on. It's critical to the efficiency of the shipping trade generally that owners can safely rely on letters of indemnity when accepting discharge and delivery instructions. And the English courts recognize this and seek to uphold the obligations set forth in LOIs, where, as in this standard wording, there is an English law and jurisdiction clause. And in keeping with that general policy, the English court will normally grant mandatory injunctions to enforce the promises set out in LOIs to provide security and to put the ship owner in funds. And they do so on the basis that damages would be an inadequate remedy. The first case that I want to look at is a decision called the Tenacity, which gave rise to a series of judgments in late 2020. The facts of LOI cases often follow a recognizable pattern. In this case, the owners had time chartered the vessel to NOC. NOC had then voyage chartered the vessel to another entity, GP. The vessel loaded a cargo of diesel in Kuwait for delivery in the UAE. The original bills were made out to the order of the financing bank, the Natixis, and at the discharge port, NOC and the voyage charterers in turn provided LOIs in functionally similar terms. The cargo was delivered pursuant to those LOIs without presentation of the bills of lading. And then what happened, as so often happens, is that the bank popped up with a fairly chunky claim for $11 million for misdelivery of the cargo. The owners would likely struggle to defend that claim in circumstances where the cargo was delivered without presentation of the bills, prima facie a breach of the bill of lading contract. And so the owners demanded that NOC put up security, and NOC passed that demand down the LOI chain to GP. Security was not forthcoming, so the ship owner applied to the English court for a mandatory injunction requiring NOC to put up security. On such an application, the court needs to be satisfied to a high degree of assurance that the LOI is engaged. And the first issue in this case was whether the LOI was engaged at all. It contained the standard obligation to put up security on demand if, in connection with delivering the cargo, the vessel should be arrested, or if the arrest or detention thereof be threatened. Now, what had happened in this case is that the bank had demanded delivery of the cargo and damages. And the message from the bank's lawyers concluded with this threat: all our clients' rights are expressly reserved and may be enforced with or without further notice to you or your agents. There was no express reference to arresting the vessel, but the judge, His Honour Judge Pelling QC as he ever was, held that this was a threat to arrest the vessel without further warning, and that the LOI was therefore engaged. So an unqualified reservation of a right to arrest is held and treated as a sufficient threat to trigger the right to call for the production of security. We see here the court taking a robust and commercial approach to the construction and application of an LOI. And I think it's worth emphasizing that courts generally are unimpressed by technical arguments on behalf of the issuer to the effect that the threat is not sufficiently far advanced or has not materialized in a sufficiently concrete form. The second issue was more challenging, and that was the argument that the court should not order NOC or GP to do the impossible. What NOC and GP said was, even if we're obliged under the LOI to put up security, we simply can't afford to do so. There isn't enough money in the companies to do that. It's a very, very unattractive argument for a party that has issued an LOI to turn around when it's called upon to perform its contractual obligations to say, oh, it's not within my power, I can't do it. The judge accepted the general principle on this application for a mandatory injunction that the court won't order a party to do that which it's impossible for it to do. However, the court said to invoke this principle, evidence must clearly establish impossibility, and nothing less will do. Heavy onus lies on the party asserting impossibility to set out the position fully and frankly. That party would need to establish that necessary funds would not be made available to it, either by its shareholders or by some other closely associated person. And a comparison can be drawn there with the approach taken in applications for security for costs. where one party says that its impecuniosity means it wouldn't be able to continue defending the claim. And the fact that a letter down the chain may be unenforceable. So the fact that GP, the bottom of the chain, might not have the funds doesn't afford NOC, at the top of the chain, a defence. The court said that this very strict approach was justified because there was a strong case that the LOI was engaged. The risk of arrest to the vessel arose from the fact of delivery, i.e. complying with the request set out in the LOI. But it was very unattractive for the charterers to give the LOI and then maintain that they didn't have the means to comply with it. And finally, the general commercial importance to the maritime hydrocarbon trade of promises in LOIs being complied with justified the strict approach. At the first hearing, NOC failed to establish impossibility. What its sole shareholder and director, Mr. S. Bastani, had done was fairly damning. He'd made large transfers of cash days after the demand was made under the LOI, $7 million in total. And his explanation for this was that it was a bonus that had been agreed months earlier by the managing director. The managing director was himself, and there was no explanation as to how the sum had been calculated or why it hadn't previously been disclosed. And the original of the document recording this agreement to pay the huge bonus was no longer available. He maintains that the decision was recorded in a letter, but he wasn't able to disclose a copy of the Word document in a form that enabled its metadata to be examined. Plainly, the judge wasn't convinced this was a bona fide transaction, and who can blame him? Any ambiguity was resolved against NOC, and the gaps in the evidence were fatal to their application to set aside the mandatory injunction, because the judge was not persuaded that it was impossible for NOC to comply. So the injunction continued. And then, amazingly, in my view, NOC had a second bite at the cherry, came back to the court with new evidence. This time they had an accountancy report from Grant Thornton, and that went through the company's assets in detail and concluded that there simply wasn't enough cash to provide any security. And the judge held that even though the conduct of the sole shareholder was commercially reprehensible, it was to be inferred from the financial circumstances of the company that funds will not be made available to it either by Mr. S. Fastani or his family connections, quite simply because any money that is provided to the company will be swallowed up dollar for dollar in satisfying the requirements under the letter of indemnity. It feels to me like this is completely the wrong result, but English law has long recognized the doctrine of a company's separate corporate personality. And on that basis, the assets of Mr. S. Fastani could not be treated as the assets of NOC. So in those circumstances, the judge felt that he had no choice but to conclude the company wasn't in a position to meet its obligations under the LOI and set aside the injunction. In a more recent decision, the STI Orchard in 2021, we see Mr. Justice Butcher on similar facts, taking a strict approach and finding that the charterers on a similar fact pattern here from the bank popping up with a misdelivery claim and carriers seeking $16 million worth of security from the voyage charterers under the LOI. The charterers said, impossible for us to comply with the injunction, therefore it should be set aside. And Mr. Justice Butcher held that they failed to satisfy the court, that it was impossible for them to comply. he drew attention to the lack of full and frank disclosure, not usually a duty that applies in these parties hearing, but here where you have such an imbalance of information, the issuer of the LOI protesting that they're incapable of complying with it is going to have all of the information. And here the judge focused particularly on the fact that the accountants who the charterers had instructed to look at their own financial wherewithal had access to far more by way of documentation that had been disclosed and provided to the ship owners, accountants and experts. And he felt that there was insufficient evidence about the management and the beneficial owners and other companies within the same group, whether they would be able to provide finance. So before I hand over to Ben, a few lessons that can be drawn from the tenacity and that line of authority. First, the value of an unsecured LOI is only equal to the creditworthiness of the issuer. You can have the best worded LOI in the world that's going to, if complied with, give the ship owner all the protection it needs. But if the issuer doesn't have the funds, then it's practically worthless. So it's always important to take into account the creditworthiness of the issuer. And if there is doubt, a bank can be asked to guarantee the LOI when it's issued, and the international group have standard wording that includes a bank guarantee as well. If you're acting for the issuer and you want to resist an injunction on the grounds of impossibility, then very clear evidence is needed. It will need to descend to the level of granular detail, and there can be no gaps, because if there is a gap, a judge will identify it and rely on it as a grounds for continuing the injunction. When you are mounting the impossibility defense, or if you are trying to unpick it, consider the availability of funds from shareholders or other closely associated persons or companies, which are likely to bear on the ability to perform. The LOI is going to be enforceable irrespective of whether LOIs down the chain are enforceable. And that's important because it's easy to take comfort from the fact that somebody down the line is given an LOI, but if they don't have the means, you in the middle can be left holding the baby. Where, as in the Tenacity case, a director or sole shareholders had large sums of money transferred to them, there may be other actions that you can take directly against that third party, and in particular, I think the merits measures, unwinding the transaction that's intended to defraud creditors would be the obvious one.
Yeah. Thanks, Tom. I'm going to be talking today about a favourite topic of mine, which is cases I have appeared in, and in particular, the Miracle Hope, which was a long-running saga. It started in the spring of 2020 with the Miracle Hope number 1. I'm afraid, for those of you hoping to hear about the Miracle Hope number 6, which was the consequentials from the trial, I won't be talking about that. I'm going to stop with the Miracle Hope number 5, which was the trial which took place last summer in front of His Honour Judge Pelling, again, as with the Tenacity, and his judgment, which came out in October, I think. So we've got here a picture of the Miracle Hope. Your anchor. And the facts are similar to those that tend to arise, as Tom says, on these LOI type of cases. The head owners of the vessel time chartered her to Trafigura. Trafigura, in turn, voyage chartered the vessel to Clear Lake Shipping. Clear Lake is the chartering arm of the Gunwale Group. Clear Lake Shipping is the Singapore entity within Clear Lake that tends to do the chartering on behalf of Clear Lake. but it's Clear Lake USA which subchartered on back-to-back terms to Petrobras, the Brazilian state oil company. Now, that is relevant for reasons that I'll come back to as to the gap, alleged gap between the Clear Lake companies. Essentially, Clear Lake was used as a sleeve because Trafigura did not want to do business directly with Petrobras. So that's the sort of context to this situation. Clear Lake stepped in the middle and a small margin for acting as an intermediary and chartering in and chartering out between Trafigura and Petrobras. Both voyage charters had an amended Shell Voyage 6 form, Clause 36, where they tinkered with the terms of Clause 36 in standard form, and you can see the wordings quoted there. The most interesting bit for our purposes is the bit in bold. Charterers, owner shall discharge such cargo in accordance with charterer's instructions in consideration of receiving an LOI as per owner's P&I Club wording to be submitted to charterers before lifting the subs, i.e. before the charter was concluded. And then it said following indemnity deemed to be given by charterers, and then it deleted the indemnity. So a slightly odd wording, not the sort of thing that a lawyer might have drafted with great care after the event, but traders have a different view on these things. The voyage charters were concluded without an LOI wording being provided to down the line from the owners all the way down to Petrobras. No wording was discussed before the conclusion of the voyage charters. The vessel loaded 1 million barrels of crude oil in Brazil, bound for China, and then during the voyage, the laden voyage, Petrobras it asked Clear Lake USA for delivery, actually I think discharge, strictly speaking, without production of bills of lading, and Petrobras expressly referred to Clause 36 that we just looked at in lieu of an LOI in their email to Clear Lake USA. Clear Lake Shipping then passed those instructions on to Trafigura word for word, and Trafigura passed the instructions on to the owners. No standalone LOI document of the sort that you have in front of you was issued. No one signed anything. It was simply the email saying, please discharge to our receivers on top. We're invoking Clause 36 in the voyage charter, at least in the 2 voyage charter cases. The owners then deliver to Hontop, who are Petrobras's receivers. I say as instructed. We'll come back to whether that was actually as instructed. Without production of the bills of lading. Bills of lading get stuck in the banking chain, as they often do in these sorts of cases. The bank, our old friends Natixis, crop up and they arrest the vessel in Singapore because they say, we have the bills of lading, where's the cargo? And the owners say, oh, we delivered it to Hontop as we were told to. And then the usual thing happened, which is that the cascade of demands down from the head owners to Trafigura to Clear Lake Shipping, Clear Lake USA to Petrobras. So then we get on to the injunctions. We're now in the spring of 2020. Trafigura applies for an injunction against Clear Lake Shipping for security to secure the release of the vessel and for defence funds in relation to the claim brought against Trafigura by the head owners, and also the head owners' funds to defend the claim by Natixis. Now, just a practical matter as an aside, this was on 1 day's informal notice, and there was not very much that Clear Lake could really say about that because the nature of the injunction application is that it's urgent. The problem for a party in the middle, such as Clear Lake, is that they don't really know what defences might be raised by the party that originated the instructions. But there's no time to find out what the originating party would say, in this case, what Petrobras would say as a defence to the application of an injunction, because they had 1 day's informal notice. There wasn't enough time to bring Petrobras in. And indeed, because there was no claim form at this stage, you couldn't also bring them in as a third party to a claim. So there's a procedural problem for an intermediate party like Clearlake. They sort of have to guess what defences might be raised, so they don't find later on, when they seek to pass the indemnity application down the line, that there's some good defence that they weren't aware of after they've been ordered to put up security. So what Clearlake did at this point in the Miracle Hope number 1 was to raise any defences it could think of which might have been raised by Petrobras. And then a week later, Clearlake has managed to get its paperwork together, so they then apply for injunction against Petrobras, also without formal notice, and both injunctions were granted, and the usual order was made, which is for security to be put up forthwith. What then happens is there's negotiations between Clearlake, Petrobras, and Natixis as to the form of order which Natixis will accept to release the vessel. This series of negotiations was not successful because, at least from the Clearlake and Petrobras side, they said that Natixis's demands were unreasonable. For example, Natixis was demanding an evergreen guarantee that did not ever expire, and on the Clearlake and Petrobras side, they said no bank will give us an evergreen guarantee. So there was a bit of a roadblock for various reasons, including that. So the injunctions are then continued on the return date by Mr. Justice Tier, and at that point there's an argument which I'll come on to, where traffickers say that there had been a breach of injunctions because the security has not been put up forthwith. So there are 4 issues in this injunction stage that I think are worth touching on before we move on to the trial. The first is the question of whether there was a valid letter of indemnity at all. So Clearlake and Petrobras both argued that there had been no indemnity contracts because, well, for 2 reasons. First, no wording was provided prior to the voyage charters being concluded, and so Petrobras said, what's the indemnity contract? What are the terms of this indemnity contract if there's no wording? And they also said the clause 36, which we looked at earlier, required a document, a standalone letter of indemnity document signed by Petrobras. And because it was just an email invoking clause 36, that wasn't good enough. Now, as with the arguments of the charterers in the Tenacity, that's not very compelling when you have asked for the discharge without production bills of lading, and then you get discharged without production bills of lading, having promised an indemnity, to say, oh, well, you can't enforce it against us because it's all too uncertain because of these formalities. Now, Mr. Justice Henshaw in number 1, and Mr. Justice Jacobs in number 2 were pretty unimpressed by this argument. They concluded that there was no requirement for a separate LOI. The clause stating that an LOI would be provided, it didn't mean a separate document. It meant that a promise to indemnify would be provided. And when Petrobras and Clearlake issued instructions saying, please discharge with clause 36 in lieu of an LOI, they waived any requirement anyway. So even if there was a requirement for standalone indemnity, that was waived by the request to discharge invoking clause 36. And as to the certainty of the terms, I'm sure you'll all be aware that arguments about uncertainty after the parties have performed an agreement are pretty given short shrift by judges, and this case was no different. The judges had to find out what the wording would be, and they had no real difficulty saying it was the international group wording, because almost all trades involve IG group, at least the ones that we see in London court and arbitration involve IG group members. So that's the international group of P&I clubs. And so when they said owners P&I club wording, what they meant was international group wording. And that was supported a little bit in this case by the charter parties, which referred to the fact that the head owners were I can't remember which P&I club it was now off the top of my head, but they named a P&I club that was within the international group, so that supported that construction. There was then an issue raised by Petrobras in the application brought by Clearlake for an injunction, where Petrobras said, hang on a minute, we gave an indemnity to Clearlake USA. Clearlake Shipping is the party on the hook up the chain. So there's no link. The link between what Trafigura is asking for and what Clearlake USA is asking for is missing. So we don't have to do anything at all. Again, not a very attractive argument, you might think. But Petrobras' argument was there has to be an unbroken chain in order to invoke any of the provisions of the indemnity contract. And Mr. Justice Jacobs said, no, the promise given by Petrobras is upon the arrest of the vessel, you will put up security. You can make that promise to anyone. It doesn't matter who it is that you've made the promise to. It's an enforceable promise. So even if there is a gap between the two Clearlake companies in relation to indemnity, you still have to put up security if you promise to do so. So he parked the contractual lacuna question, which is relevant also for damages, and I'll come back to it, by saying you don't need the unbroken chain in order to enforce the mandatory injunction aspect of the LOI. The second issue was what does forthwith mean? Philosophical question. And there was no authority really on this, but it's the standard wording. As I said, there was some negotiation between Natixis and the parties that had been ordered to put up security, which had gone nowhere really. Trafigura said, well, it's been 3 weeks since Clearlake was ordered to put up security, and they haven't. So they haven't put up security forthwith. You can infer that from the delay in and of itself. In any event, it doesn't matter what the negotiations were, because Clearlake and Petrobras just had to give the security that was demanded by Natixis, whatever it was. And then the third string to the bow was, if that's wrong and Natixis' demands were unreasonable, then what Clearlake and Petrobras should have done was put money into court in Singapore, because they could always do that as a means of putting up security. And so on that basis, the injunctions were breached. Now, Mrs. Justice Tier had to consider this on the return date, and he gave the definition on the slide of forthwith. Essentially, you need to put up security in the shortest practicable time. So you don't have very much time, but if you can say, I've been trying really hard and I haven't been able to put up security, then that will be sufficient for a period of negotiation. And he also held that there was no requirement to just give in to whatever was requested by the arresting party. Now, ordinarily, what you would do in that situation would be go to the court in the arresting jurisdiction and say, the arresting party is demanding unreasonable things from us, so please, judge, tell us what we have to do to put up security. Now, this was in the spring of 2020, and the Singapore court was essentially shut, so there was no opportunity to do that. And in those circumstances, Mr. Justice Tier said, well, I'm going to have to resolve this issue because the Singapore court can't. But this is an unusual situation, and ordinarily it would be the arresting court to do so. And Mr. Justice Tier said, I'm not going to make any decisions about the negotiations, because he was a bit nervous about doing that as a matter of Singapore law and Singapore jurisdiction under the arrest convention. But what he did say was, if you've got trouble negotiating a bank guarantee or a parent company guarantee or whatever it is, what you do is you pay money into court, because that's always a way of securing the release. So in his view, that was the obligation of the parties that were subject to the indemnities. And that is then what was done following the return date. It was about 70 million, I think it was more than $70 million. So finding cash of $70 million was not an easy thing for a company even like Clearlake or Petrobras to find. It was not reach down the back of the couch levels of security required. So on this question of the cash security, Clearlake did not really want to try and find $70 million because it expected Petrobras to pay that money into court as it was ordered to do, but there was a risk that Petrobras would not satisfy its obligation under the indemnity to do that. So what Clearlake said was, can you give us a few days to see whether Petrobras pays money into court before Clearlake has to find that money, because $70 million was not cash in hand. They'd have to go and borrow it. Now, Mr. Justice Tier said that he could see the logic and the commercial attraction to doing that to avoid unnecessary expense, but he held that the court didn't have the discretion to make that order because Trafigura was entitled to look to its immediate counterparty for security to be put up forthwith, and that did not allow for waiting to see whether the party down the line would perform or not. So this goes back to the point that Tom was making about each party being entitled to look to its immediate counterparty for performance. So the staggering was unsuccessful as an application by Clearlake. And what happened was that both Clearlake and Petrobras went and found their $70 million, and then Clearlake sort of waited to see whether it needed to pay it into court, and it turned out that Petrobras performed its obligation, and so Clearlake incurred the costs of getting the money together, which it then claimed against Petrobras, but didn't actually need to pay the money into court. Fourth issue was costs, and I just mentioned this briefly because it's of some interest in the three-party plus situation. Clearlake sought to pass on its costs of the Miracle Hope number 2, its own application, onto Petrobras. Sorry, both applications onto Petrobras. So even the costs it incurred in defending the claim brought by Trafigura, as well as its own costs in the application against Petrobras. Petrobras said, no, you decided to resist the applications brought by Trafigura. That's your own lookout. You can't look to us for that cost. Mr. Justice Tier said that essentially, as long as the party in the middle maintains the positions up and down the line, it can seek the costs against the unsuccessful party of both sets of proceedings, even though there are different actions, different claim forms, all the rest of it. He sort of sidestepped the procedural side of this, which is a little bit complex, and simply ordered Petrobras to pay the costs of the proceedings it wasn't a party to. I think there is a procedural mechanism to do so. Mr. Justice Tier wasn't really interested in what that procedural mechanism was. He simply just ordered Petrobras to do so, and they did. But the minute that Clearlake stepped out of the shadows, if you like, and made its own position in either set of proceedings, it was acting at its own risk and couldn't recover the costs from the unsuccessful party. So that's something to bear in mind if one is acting for the party in the middle. You want to hew as close as you can to the parties up and down the chain to avoid independent costs risk. So we finally get to the trial, Miracle Hope number 5. You will recognise there Michael Ashcroft, Rob Thomas, and Henry Byne Cook, who were the lead barristers for Trafigura, Clearlake, and Petrobras, respectively. And Petrobras maintained its argument that there was no valid letter of indemnity, and again, it lost. Although this time, His Honour Judge Pelling, who was the trial judge, had a little bit more difficulty with the slightly unusual clause 36 as tinkered with by the parties. He did ultimately conclude that the forelifting of subs language was not a problem, but he did struggle to identify exactly what that clause meant when there was no LOI wording provided in advance. Nevertheless, his conclusion was that once you invoke that clause in the process of performing the contract, there must be some sort of agreement to indemnify against delivery without production of bills of lading. And there was another argument raised again, which was, when is the indemnity, the indemnity document? And again, essentially for the same reasons as Mr. Justice Jacobs and Mr. Justice Henshaw, the trial judge held that there was no need for a standalone document, or even if there was, it had been waived by the indication. It was fairly unremarkable application of principles, I think, there. But there was an interesting argument to the effect that discharge doesn't mean delivery. And how this came about was that Petrobras, in its instructions, said, please discharge the cargo without production of bills of lading. And it also named the receiver on top. But at trial, Petrobras said, well, what we said was discharge, not deliver. And discharge means bring it ashore. It doesn't mean give it to anyone. So when we said, please discharge without production of bills of lading, what we meant was, please owners, find some space at the terminal, hire it out, put the oil into that terminal. Don't give it to anyone, whatever you do. Just hold on to it, and then we'll tell you what to do with it later. And what we're doing is asking you to do that. That's what we mean by discharge. We don't mean deliver it to Hontop. My goodness, what were you thinking? There is case law to the effect that discharge and deliver do mean different things, and discharge means bring ashore, whereas deliver means part of possession of the goods. But the judge said that the context was critically important, and when Petrobras said, please discharge without production of bills of lading, our receiver is Hontop, what they were asking was for delivery to Hontop. That was an ingenious argument, but not one that really got much traction at trial, I think it would be fair to say. Now back to the contractual lacuna, which was the judge's way of describing the problem that Clear Lake Shipping was the voyage charterer from Trafigura, whereas Clear Lake USA was the disponent owner in the sub-charter to Petrobras. This was more of an issue at trial because Clear Lake USA was claiming damages or an indemnity in respect of its own losses. So Petrobras said, you haven't suffered any losses because you're not the party liable to pay Trafigura if there is a valid indemnity. So this couldn't be sidestepped as it could at the injunction stage, and Clear Lake had to tackle it head on. And Clear Lake did so by providing evidence from directors of Clear Lake USA and Clear Lake Shipping to the effect that there was always an intention, whenever this mismatch occurred, for there to be an indemnity internally within the Clear Lake company. So if Clear Lake Shipping becomes liable up the indemnity chain, then Clear Lake USA promises to indemnify Clear Lake Shipping so that the liabilities can be passed up the chain. And similarly, the charter parties, there was an implied charter party down the chain so that payments could be made, and so on and so forth. Now, Clear Lake didn't document this in any form contemporaneously, but there were some email exchanges which were consistent with that intention to make sure that there was a unbroken chain in relation to the charter party and indemnity contract. That said, I think it'd be fair to characterize the evidence of the Clear Lake witnesses as being somewhat vague on exactly what that intention was and when it manifested. Nevertheless, the judge concluded that there was an intention to pass the liabilities and benefits of the contract up and down the chain, and therefore Clear Lake USA was liable to Clear Lake Shipping in respect of Clear Lake Shipping's liability to Trafigura. And it was sufficiently certain that there was an implied internal agreement. Nevertheless, the judge also said, even if the Clear Lake directors hadn't even thought about this question, there would have still been grounds to imply an indemnity, because it would be necessary to give effect to the commercial reality and the context, which is that a group of companies is not going to want to be left holding the baby and not being able to pass liabilities up and down the chain. Now, I think that's likely to be the conclusion in most cases, although I think it's fair to say it is going to be fact sensitive as to whether that implication can be made in any one case where there's a corporate group with a mismatch in terms. Now, Clear Lake had a sort of secondary argument, which was that Clear Lake Shipping could enforce the indemnity given by Petrobras to Clear Lake USA on the basis that Clear Lake Shipping was a servant or agent of Clear Lake USA in achieving the delivery without the production of bills of lading. This is sort of an extension of the principle recognized in the Lempong Glory, the fact that the head owner is a servant or agent of the disponent owner, the person who receives the indemnity. And so the head owner under the Contracts Rights of Third Party Act of 1999 can sue directly, even though it's not privy to the indemnity down the line. The judge, this is sort of overturned because he didn't need to decide this, but he thought that Clear Lake Shipping was, just as an intermediate charterer, was not a servant or agent of the charterer down the chain. I think that is open to some doubt. I think it's hard to say what the right answer is to that, but it's a question of construction of servant or agent. I think in another case it might be worth pressing that point rather harder and making the judge in any particular case decided if it's important, as it might be in a chain of indemnity contracts. If, for example, your immediate counterparty is impecunious and isn't going to provide security. So, final slide you'll be relieved to hear is just some implications from the Miracle Hope, which I've set up on the screen. The letter of indemnity is a separate independent contract, and that was particularly important in the contractual lacuna point we were just discussing, because you can't enforce it on the basis that there's a charge party in existence. It's also relevant to the question of the forthwith and the staggering as well. Always important to bear in mind that each contract is going to be separate and separately enforced. But I think it's also fair to say that courts will be robust in trying to uphold and enforce contracts of indemnity in the maritime context. And I think both of these cases show that quite clearly. The second bullet point is that essentially you don't have to do whatever is required of the arresting party in order to put up security. You can ask the court in the arresting jurisdiction to set the terms for the security as long as they're not shut. Forthwith and on demand don't necessarily mean immediately. That's context specific. I think this is a point I didn't really mention, but just so that you're aware, if you aren't already, Trafigura argued that because this was an indemnity, they were entitled to their costs on an indemnity basis. And Mr. Justice Tier said, no, that's not right. You only get your costs on a standard basis as a matter of assessment. You can claim any difference between the standard and the indemnity basis damages if in order to make good your indemnity claim. And then the next bullet point is the point about Petrobras being ordered to pay the costs that were in an action that they were not party to. The penultimate bullet point, I think it would be sensible to bear in mind as a trader that when you tinker with a standard form clause, it's probably a good idea to get legal advice so you don't end up giving fuel to parties at the end of an indemnity chain to run the sort of arguments that Petrobras did in this case. But I appreciate that none of us are traders, and we probably don't know exactly how these things work, or at least I don't, how these things get concluded. And then finally, the contractual lacuna point. I think Clear Lake now have a booking note system where they evidence the charge party internally, and I think they also now pass an email. The same person will pass an email to themselves saying, "I hereby invoke the indemnity under the booking note charge party," and that again avoids the sort of arguments that arose in the Miracle Hope, and it's probably a good idea to avoid having to argue the case on the basis of an implied contract. Thank you for listening. Tom, I see
a couple of questions.
great,
I wasn't just
high-tech
checking my emails.
questions. Okay.
So we've got two sliding questions. Of course, if anyone has got any other questions, please do feel free to ask them.
Very topical.
Yeah.
I don't think I have a clear enough sense of what happens with the bill of lading passing through the banking chain with an electronic bill. Presumably, the bill is still with the bank, and the bank is the holder of the bill at the time of the arrival of the ship in certain circumstances. And so I would have thought that there will still need to be indemnities in those circumstances. But I confess I'm speaking from a position of ignorance as to exactly how the electronic bill works. Tom, do you have any thoughts?
Well, I also speak from a position of ignorance, but I think going back to the two examples I gave at the beginning, why the bill could be held up. The first is it gets caught in the chain of contracts and takes a while to physically get down to the receiver. I can see that electronic bills, insofar as they're much more quickly transmitted, are less likely to be held up in the system in that way. But what we saw from, I think, all of those cases is what's actually happened is that the bank is holding on to a bill for security.
Yeah.
And I think that even with an electronic bill, as a form of security, the bank's still going to be holding on to it. So there's probably going to be just as much pressure at the discharge port on the ship owner wanting to get the vessel away, on the receiver wanting access to the cargo. I think that we'll find that LOIs continue to have life in them yet.
So that's what happened in, I think, in both cases, wasn't it? The Natixis had the bills of lading because the receivers hadn't paid Natixis. Natixis was the financing bank, and the bill of lading was its security.
Yeah, because I think the bills were to the order of the bank.
Yeah.
Presented to the bank. The bank's paid out on the letter of credit, and then it's not going to release them until it's paid by the buyer.
Yeah.
I think the answer to that is yes. There would be, in the same way that if you're responding to a security cost application, you say you can't comply with an order. The court would expect you to explain why you can't go and get financing from a bank. So
it wouldn't be impossible, would it? If you could get a loan. So.
Yeah. So it doesn't. You don't. The question is not: is it possible for the company to comply using its own assets? Its cash in the bank, or by selling one of its assets. It's in any way, even if it goes to a third party, whether it's a bank and beneficial owner or another group company, can it somehow get these funds together?
Yeah. Any other questions? Any analog questions? I think there's a distinction between what was refused in the Tenacity was the mandatory injunction. I don't think there was a question, Tom, correct me if I'm wrong, that the party required to indemnify would be liable in damages or would be liable to pay the indemnity. It was just that they couldn't be forced to do something that they couldn't do. So they'd be penalised, and I suspect they'd be wound up in that case if it was pushed. If it was worth it to enforce the indemnity at a trial at a later stage. So that's obviously a penalty for Mr. Esfastani in that case, was that the company gets wound up if there's not a compliance with the indemnity. Tom mentioned the guarantee as well as another way of sort of strengthening the efficacy of the indemnity. And there's also the possibility of the owner, at least the head owner, skipping its immediate counterparty and trying to enforce down the line against a party further down on the basis of the length on glory. So some initial thoughts from my perspective. Tom, do you have any?
What happened with me? So the evidence that really satisfied the judge in the Tenacity was an independent report from a reputable accountancy firm that went through the company's finances minutely and concluded they simply didn't have the assets, and by extension, a bank looking at their financial situation would not be lending money to them. There'd be nothing to secure it against. They would be very unlikely to ever repay it. So it is possible, but as demonstrated by that more recent decision in Orchard, it's very, very difficult. And because it's such an unattractive argument, the judge is going to go through sort of line by line and testing the proposition that it's impossible. And if there's any gap, I think he's going to find against the issue.
Well, so in the typical situation where a charter party says against production of LOI, owners will deliver without production of bills of lading, they can't subsequently impose conditions like that. So that they will be in breach of contract if they say no, an indemnity isn't enough. We also want this, that, and the other. Now, whether that's the case where you know that your counterparty is in a worse position than at the time of the conclusion of the contract, I suspect that doesn't matter. You're taking that risk as the party promising to deliver against an indemnity. So I think if you were worried about the creditworthiness of your counterparty, you might well want to say secured by a bank guarantee or whatever else in your charter party to avoid finding yourself in that situation.
Yeah, I think that's right. And as well as that kind of protection, you can also ensure that the wording in the LOIs down the chain is sufficiently broad that it will allow the ship owner to bring an action under the contract's rights against third parties.
Which I think the standard form does.
Yeah.
But, now, if there isn't a clause in the contract, then the owners aren't obliged to deliver without production bills of lading at all. So they can just say, no thanks, we'll wait for the bills of lading. But that would, that's a different situation. And then they can do what they like. They can say, no, we'd like bells and whistles and all the rest of it. But yeah.
Well, in order to engage the LOI, the cargo is almost always delivered. So the request would be to deliver the cargo to the named person, and the ship owner will have given delivery. Sometimes there's a dispute as to whether the ship owner has complied with that obligation, and the difficult issues arise because when the vessel gets to the discharge port, the cargo will be discharged, but the cargo might be discharged to effectively a stevedore who's working at the port, and the owner may not know and find it very difficult to prove that it's actually ultimately being delivered to the person named in the LOI. And that can cause issues when it comes to applying for a mandatory injunction, because the court has to be satisfied to a high degree of assurance that the LOI has been engaged. I think the answer to your question is, generally speaking, the cargo will be assured if these disputes arise. So it's the vessel that's arrested.
Yeah, I think in the Miracle Hope, the cargo is long gone. It had gone into the terminal and it had gone on somewhere else, and it had been mixed in with everyone else's oil and all the rest of it. So when the Natixis is deciding whether to sue Hontop or to sue the owners or both, the easy target is the ship that's sitting there. And you can arrest it and then get security for the release of the ship. That's just an easier target, I think. It certainly in the facts of our case, and I suspect in many cases it would be easier than trying to find the goods that have already been delivered to the receiver and then gone wherever else in that jurisdiction. Yeah, I mean, Petrobras, in our case, have been paid. And so looking to them for the they've been paid and they had sold to Hontop, so they had I suppose they had a claim against Hontop, perhaps. But I think it's sort of a triangle, with Hontop being liable sort of to both its seller and to the bank, I suspect. And it just then depends who you want to enforce your rights against. And I suspect Natixis thought the vessel was easier, because the cargo had gone. So that's often the case. Owners to deliver would be safer wording, because discharge allows for the not very attractive argument that it's just put the goods ashore and keep possession of them, which was essentially the Petrobras argument. So deliver is the word you'd want to use to avoid that sort of argument. Yeah, I suppose, I mean, in the Miracle Hope case, there wasn't a particular wording that, that what should have happened was I think it's the B wording or the C wording, I can't remember which one it was, should have been provided in advance. And then there couldn't really have been an argument to the effect that, no, you should have, the wording that involves a guarantee, and I can't remember which letters are which, is the one that's required. When there's some uncertainty about which wording is required under the contract, I can see there would be an argument that actually it's the wording that involves a guarantee because you're not creditworthy. Yeah. Yeah, I suppose you'd be then saying that it's some sort of implied term or implied sort of limitation on the entitlement to demand delivery without production of bills of lading if you can't actually indemnify on the facts. I don't know about you, Tom, but it seems to me that that's not going to be a straightforward argument to run, because you'd say you took the risk by promising to deliver without production of bills of lading, and you took the risk that I would be able to indemnify you under that charter council.
I agree. I think it's always difficult to imply terms,
yeah,
particularly where the term is controversial. It's especially difficult.
Yeah, I think we're overrunning, so we should probably call time on it. Thank you very much, everyone, for coming.
Thank you.